All right, good morning, everyone, and welcome to our second and final employer and workforce seminar of 2020. My name is Darren Rogers, and I work for the Utah Department of Workforce Services, and I also chair the Ogden Chamber's Workforce Committee. It's my pleasure to welcome you to our seminar today. As a way of announcements and upcoming events, I would like to make you all aware of tomorrow is the Department of Workforce Services our virtual job fair. And as employers, if you are hiring and are not participating in this event, you may reach out to me and I will get you contact information so that you can sign up. I will place my contact information in the chat feature so you can reach out to me. If you're not able to attend tomorrow's virtual job fair, there are two other events, one on December the 3rd and one on January the 7th. And those are free to participate in. Also, there is an event on November the 10th, which is the apprenticeship job fair. And if you're a company that offers or interested in pursuing apprenticeship opportunities, this is a free event, and again, you may contact me, and this is sponsored through the Utah Department of Workforce Services. On November the 13th, there is a chamber event. It's the Northern Utah Business Symposium. The subject is Customer Service Perspectives in Business to Business and Business to Consumer environments. And we have four wonderful speakers. We have Jill Calton from UMB Fund Services, Matt Wardle from JD Machine, Tara Lindstrom with Jamba and Pyology, and Justin Callis from Sam's Club. So you will want to register for this event, and it is on Friday, November the 13th. And then lastly, our next workforce meeting is on November the 18th. We normally meet the fourth Wednesday of each month, but in lieu of Thanksgiving, we will meet the week prior. And that meeting starts at 8 o'clock and will be a virtual meeting. So now, why we are all here is to listen to Ryan. Ryan Nilsson is with Employers Council. He's also a member of our Workforce Committee, and we're really honored to have him present. Some background information on Ryan. He attended law school at the University of Florida in Gainesville. One of his significant achievements was an appeal to the Colorado Court of Appeals and later to the Colorado Supreme Court, which impacted Colorado law and resulted in two published opinions. In 2010, Ryan joined Employers Council. He provided employers with consultative legal advice with a focus on strategic and practical solutions in a variety of areas of employment law and human resources. In 2017, Ryan became the Utah president of Employers Council. He holds SPHR certification. So Ryan, we'd like to turn the time over to you, but before we do that, just as a reminder, everyone's mics have been muted, and if you wish to have questions, please put your question in the online chat, and then when Ryan opens up for questions, I will read those questions to him. We will go until about 5 after the hour of 9 a.m. Ryan.
Great, thanks, Darren. Good morning, everyone. As I go through the content today, please put your questions in the chat. I'll try and deal with them as best I can with the content at that time. And again, as time permits, we'll open it up at the very end. I guess they'll unmute you, and then it's open mic. So today, back to school, our obligations under the FFCRA. This has been, frankly, a fascinating and at the same time overwhelming subject, and it constantly changes. In fact, just last week, the CDC updated their information regarding what is close contact, which affects our obligations for contact tracing. A few weeks before that, we had updated regulations that came out. And just recently, too, the state initiated a program like the paid sick leave for employers. So we're going to cover all of that today and also talk about our back to school obligations. So here we go. I want to first point out that there are lots of resources available to you. The first one of the three links here is the Employers Council webpage. We actually dropped the firewall for all of our coronavirus resources. It's all there, all of our articles, our forms, our updates, explanations, stuff like that. You can have access to that. But the other two references here are something that I would recommend you keep, you bookmark, and you review when you're analyzing FFCRA situations. The first is the actual Code of Federal Regulations. So this link takes you to the actual language of the regulations. These are the most current version that reflects the recent update. The last link is the DOL FAQs, the frequently asked questions on the FFCRA. If you haven't bookmarked these, please do so. They are relevant. There's a lot of excellent content there, and frankly, we use these all the time to refer to as we answer questions that come in on the FFCRA. All right, so what I want to do today is broad picture, a reminder for probably most of you what the FFCRA provides, what the recent court case did, how it affected, and then subsequently led to the modification of the FFCRA. We'll talk about how those modifications affect the day-to-day management of the FFCRA. We'll get to the school component. What do you do with your kids or employees who have kids? And then as time permits, I have some common issues and questions that we've been dealing with for the last few months that I've worked into the slides. We'll cover as many of those as we can. And what I don't cover, the PDF of the slides will be available to you. Lisa through the chamber will circulate that. So you'll have whatever I don't cover today. All right, so this law is unique. It has a sunrise and a sunset. December 31st is when the law, at least right now, goes out of effect. I wouldn't be surprised, considering where we're at currently with case counts across the US, if the law was extended into 2021. As of right now, it's not. It will sunset at the end of this year, but hold tight, wait for more. What the law does, as you know, it creates two emergency paid leave laws, the emergency paid sick leave and the supplemental or emergency FMLA. Paid sick provides up to 2 weeks or no more than 80 hours of paid sick leave, and the FMLA, the expanded FMLA, provides up to 10 paid weeks. We'll talk about the money, we'll talk about how all that works in a little bit. Now, a common misunderstanding about how employers pay for these leave laws is addressed in this last bullet point here. You as the employer, you're not paying for this out of pocket. What the law does is it creates or allows for you to tap into the taxable withholdings that you normally withhold during your payroll process and then later remit to the IRS. Well, that bucket of money that you withhold is what you tap into to pay the paid sick leave. You then file at some point in the future with the IRS and ask for a credit based on the amounts that you've withheld and paid out to your employees. We'll talk about the types of documentation that you need to justify that. I'm not your tax professional, but that's how that works. And at some point in the future, probably next year, when we begin filing our taxes, we'll have more clarity on how we make those claims for credit through the payroll process. Okay, so if you are a private employer, the FFCRA applies to you if you have 499 employees or less. Now, here's the kicker though. You count the number of employees at the time an employee makes a request for leave. So for those of you who may have been hovering right around 499, if you go above 499 and someone asks for leave, technically at that point, you are no longer a covered employer because you exceed the 499 ceiling for eligibility or for coverage. So anytime an employee makes that request, you stop, you count employees on the payroll. You also include the number of temporary workers that are working with you as part of that number. There are some limited exemptions for employers. If you have 1 to 49 employees, you have some flexibility to deny certain coverage or certain benefits of the leave, and we'll talk about those today. If you are a public employer, the good news is if you have one or more employees, you're covered. So you have to provide FFCRA protections to your employees. As with most federal statutes, we first look at who's covered, and then second, we talk about who is eligible. To be an eligible employee under the paid sick leave, you show up on your first day of work, and you are now eligible to take paid sick leave. If you want the paid FMLA, you actually have to work for 30 calendar days or be employed for 30 calendar days before you become eligible to take that form of paid leave. Very unique in those instances, especially with the FMLA, which has, in a traditional format, a much longer and more comprehensive eligibility requirements for employees. But for purposes of the FFCRA, this is it. 1 day for the paid sick leave, or just show up on day one, or for the paid FMLA, 30 days as an employee with the employer. Now, soon after the FFCRA passed and the initial regulations went into effect, we had a lawsuit. This is what lawyers do. We seek for clarity. We seek to reconcile contradictions in the law and in the regulations, and that's exactly what this case sought to accomplish. So we had this federal district court case filed in the Southern District of New York, and it alleged certain things or claimed that the law needed to reconcile certain things, or the regulations needed to reconcile certain things as was dictated in the statute. So the suit was filed on April 14th. The decision came out on August 3rd and tossed on its head some aspects of the FFCRA for those of us who are trying to apply it on a day-to-day basis. So this case, which had national recognition and application, invalidated 4 parts of the DOL regulations. Now, one point that I want to help you in terms of understanding statutes and regulations. The statutes are what Congress passes. They are the framework, typically, of how a law will work, but it doesn't contain all the details. That's where the regulations kick in. So the statute provides the framework, the regulations paint with a lot more color and detail and really help us to understand what the statute means and how we apply it. Well, this court case said the regulations have some problems. First, the case invalidated the requirement that work be available for the FFCRA to apply. They said the DOL, you've really not explained why that needs to be and reconciled it with the language of the statute. The second was that the employer needed to consent to intermittent leave. They said that shouldn't have to happen. Third, they invalidated the definition of a healthcare provider, saying it was way too overbroad. And lastly, they invalidated this requirement that employees provide notice and documentation before taking FFCRA leave, saying in essence the regulations exceeded what the statutory language allowed. So this case happened. Well, the DOL responds with revised regulations. They released these last month on September 11th, and they went into effect on September 16th. That was a busy week for a lot of HR professionals and employment law attorneys. In the regulations, the DOL agreed to some of the points the court case made, but doubled down on what they had said before and, in my opinion, fixed and clarified the issues. So we're all good now, at least for the time being. What was reaffirmed by the DOL is the requirement that work be available, but that the employee is unable to work because of a qualifying reason in order to take FFCRA leave. So they reminded and reaffirmed that you have to have work available for you, but be unable to work in order to take one of these 2 FFCRA leaves. The second thing that the DOL reaffirmed and doubled down on is this requirement that an employer must approve intermittent leave. For those of you familiar with the traditional FMLA, intermittent leave is a very well-known concept, and the DOL pointed to the FMLA regulations and said, in essence, see, We do it for the traditional FMLA, we're going to do it for the FFCRA version of the FMLA. What the DOL, however, did change, and we'll talk about a couple of these changes today, is they modified the definition of a healthcare provider. It was extremely broad to begin with. They narrowed it and basically adopted the healthcare provider definition straight out of the traditional FMLA regulations. The second thing that the DOL changed is the notice requirements when an employee is requesting emergency or the supplemental FMLA. Before, they said you have to request it in advance. After this case and with the amended regulations, they modified that, which we'll cover. Okay, so that's the state of the state with all things FFCRA, how we got to where we are today. What I want to focus on now is high level, some key points on both the paid sick leave and the paid FMLA, weaving in some changes that the state and the CDC has recently come out with, and bottom line, what that means for you as you navigate through this and try to apply it on a day-to-day basis. So these are the 6 reasons that allow for an employee to take paid sick leave. These come right out of the statute. I've abbreviated a couple of them just for brevity to make them fit on the slide, but this is the language from the regulations and the statute. You'll notice number 5 has a couple asterisks there. That's because that justification for leave overlaps with the paid FMLA. They are the same, and that's the only reason that allows us to use the paid FMLA and apply it for an employee. So let's briefly go through these. Number 1, you have an employee, and a couple points to remember. Work must be available, but the employee is unable to work because of one of these reasons. So keep that in mind. Those are key points, they're triggers. We don't apply the statute unless work is available, but the employee is unable to work or telework because of one of these reasons. The first one, the employee is subject to a federal, state, or local quarantine or isolation order. Now, the word order for a lawyer has a pretty defined meaning, but this regulation is much more comprehensive and inclusive. It includes, in fact, directives from the state or federal agency or government regarding quarantine or isolation. Now, think about that in the context of where we're at right now. In the state of Utah, we have quarantine and isolation directives that are issued to individuals who test positive or who are symptomatic or who may have been exposed in close contact with someone who is symptomatic or has tested positive. So when you have an employee who falls under a contact tracing notification that they've been exposed because of close contact, or they are symptomatic, or they are have tested positive, they fall under a directive or an order to quarantine or isolate, which means they become eligible, if they meet the requirements, for the paid sick leave. And the CDC modification of what is close contact, changing this last week, will affect this. Close contact used to be 6 feet within 6 feet of someone who is symptomatic or is tested positive within a 48-hour period, or for 15 minutes over a 48-hour period. Well, last week the CDC changed that to say you're within 6 feet for 15 minutes over a 24-hour period. So it's not 15 consecutive minutes, it's 15 minutes measured over a 24-hour window of time within a 48-hour look-back period. So if you have employees who meet that definition of close contact, they're going to fit under number 1 because local quarantine and isolation directives or orders will apply to them. All right, number 2, your employee has been advised by a healthcare provider to self-quarantine. And that has 3 components to it. The employee either has COVID, may have COVID, or is particularly vulnerable to COVID, and the doctor in any one of those situations is advising the individual to self-quarantine. So again, healthcare provider, very broad definition. It includes a lot of people in the medical profession. Any one of those who is advising this individual to self-quarantine because they have it, they may have it, or they're vulnerable to it would fall under paid sick leave protections. Number 3, your employee is experiencing symptoms of COVID and seeking a medical diagnosis. Now, this is a conjunctive requirement. You must have both parts. They are experiencing symptoms and doing something to obtain a medical diagnosis about that. Now, the time in which they spend seeking the medical diagnosis would count as paid sick leave. But once they receive a medical diagnosis back, for example, a test result that says you're not positive, this justification for leave will end, okay? Number 4 is I, your employee, am caring for someone who falls under number 1 or number 2. So I'm a parent, for example, or it could be a caregiver, and I'm caring for an individual who's subject to a federal, state, or local quarantine order or isolation order, or I'm caring for someone who has been advised by a healthcare provider to self-quarantine. In that instance, even though I'm not the one who's sick or afflicted with the COVID, I'm caring for someone who might, and therefore paid sick leave is available for me. Number 5, as I mentioned, this is the combo. This hits from both sides of paid sick and the paid FMLA. I, the employee, can't work because I am caring for a son or daughter when the school or place of care has been closed, or the child care provider of my son or daughter is unavailable or is also closed. All right, those are the reasons that trigger paid sick leave under the FFCRA. Number 6 is a catch-all. It really just allows for certain secretaries within the cabinet of the executive branch of government to get together and say, we think we should add something more to this. Hasn't happened yet. It could, but for now, number 6 doesn't mean anything for us. All right, those are the eligibility triggers for the paid sick leave. Now, as I mentioned earlier, how much leave do we get? Well, that depends on whether you are full-time or part-time. If you are a full-time employee, which the regulations define as at least 40 hours per week, I know that is different from the ACA definition of full-time. It's different from your internal, perhaps, definition of what is full-time. This is just how the FFCRA defines it. So at least 40 hours a week, I am now full-time. Then when I am eligible for and ready to take the paid sick leave, what I am paid for is the number of hours that I'm normally scheduled to work, but no more than 80 hours over a 2-week period if I'm taking it in a block format. So if I work 50 hours in week 1, I can take 50 hours of paid sick leave, but I only have 30 hours available in that second week of leave, so a maximum of 80 hours. If I'm a part-time employee and I work a regular part-time schedule, meaning it doesn't fluctuate drastically from week to week, then I'm eligible for the number of hours that you normally schedule me to work over a 2-week period. If that's 25 hours, then I'm eligible for 25 hours of paid sick leave in week 1 and 25 hours in week 2, if I take it in a block format. If I am a part-time employee and my schedule fluctuates drastically from week to week, what the regulations require that you do is math, and you have a look back period. You're looking back basically 6 months and trying to calculate an average or an average of the regular work week, what that is, and then that becomes the measurement that you apply. So in that instance, look at the regulations if you need to do the math to make sure you track it and math appropriately. All right, well, how much money is available depends on the reason for the leave. So under the paid sick leave, if I'm taking leave for reasons 1, 2, or 3, I am paid the higher of one of these 3 options. Now, in my experience, especially here in Utah, because we have a federal and state minimum wage of $7.25, most individuals make more than that. So we're looking at number 1. How do we determine what the average regular rate is? Well, the DOL regulations require that, again, you do math. Here's the calculation. Total compensation over a 6-month period divided by total hours over that same 6-month period equals a weighted average regular rate. So in essence, you're looking at total compensation on a work week basis divided by total hours on a work week basis to account for this weighted average regular rate. In the regulations, which is in the link that I gave you in that first slide, it does specifically go through how to make that calculation. This is the formula, but it requires that you do math to properly calculate the average regular rate. Once you've done that, what you're paying that individual who takes leave for reasons 1, 2, or 3 is up to $511 per day. So whatever their regular rate is, pay that. If it's $335 a day, that's what you pay. If it's $750 a day, you can only pay and are capped at $511. Now, you can pay more than that, but the IRS will not allow you to take the credit. The credit is only up to the $511, or for a total of $5,110 for the paid sick leave for reasons 1, 2, and 3. If you fall under reasons 4, 5, and 6, we pay 2/3 of the average regular rate, and that amount is capped at $200 per day for a total of $2,000 over that 80-hour or 2-week period. All right, so that's how much money we pay. Couple do's and don'ts when we think about the paid sick leave. Do not require your employee to search for or find a replacement worker to cover paid sick time. In this instance, it's very much like the traditional FMLA. If I'm eligible and I have the leave, you give it to me whether you like it or not. And I'm not required to find my replacement. That's on you as the employer. You also cannot require the employee to use other paid leave before they use the paid sick leave. Now, what's interesting about that language is how it affects the next slide and this state program that I'll talk about in just a minute. A couple things that you can do under the paid sick leave is you may require your employees to provide notice, but not in advance. You may require that they provide notice as soon as practicable of their need for leave. The way the regulations define that is the day they take leave, that first day, sometime later that day is when they're required to give you notice of their leave. So think about that from your attendance process. That's probably a little backwards. Typically, we require the employee to give us notice in advance. Well, for paid sick leave, the regulations say, nope, can't do that. I don't have to tell you in advance, but I do have to tell you the day I begin taking leave. Second, another thing that you can do. You can require your employee from that point forward to follow your normal attendance process when requesting to be away from work. And lastly, you can permit your employee to supplement their paid sick leave with a version of the accrued leave that you provide them. Now, supplement is different from substitute. You can't substitute, but you can allow the employee to supplement that amount they receive from their paid sick leave. So the $511 amount or $510 amount or the $200 daily amount, you can allow them to add to that by tapping into their accrued paid sick leave. You don't have to, but it is an option that the regulations allow so that the employee can be made whole from a wage perspective for the time that they are absent. Reminder though that you only get the tax credit for the amount specified in the regulations for the paid sick leave. Okay, so 2 weeks ago, the Department of the Labor Commission here in the state, in conjunction with GoEd, released a new program. It started on October 1st and caught a lot of us by surprise. It mimics in many ways the paid sick leave. It is administered again through the Labor Commission, and application is controlled through GoEd, but it's the Small Business Quarantined Employee Grant, or the SBQEG, just rolls off the tongue. Here's who it applies to and how it works. This program went live October 1st. The state of Utah received $2 million in grant money from the CARES Act through the federal government. Again, as I mentioned, it's administered through the Labor Commission, but you as an employer apply through GoEd, and the links from the Labor Commission funnel you to the GoEd website. These monies are for reimbursements to small employers who are paying their employees to stay home during quarantine or isolation. Sounds very much like paid sick leave, doesn't it? So here's who's eligible. You must be a small business with no less or no more, than 50 employees here in Utah. I take that to mean that if you are a multi-state employer, but you only have 50 employees or less than 50 employees here in the state of Utah, that you would still be eligible. I've seen that happen. If you have meet the required employee threshold, you must have one or more employees who have received a notice through typically contact tracing that they have to quarantine or isolate due to a positive kit test or exposure to someone who's tested positive. And then you, the employer, continue to pay out regular wages while they are in quarantine or isolation. And this can be used before or after the emergency paid sick leave, but not simultaneously. Now, I'm not your lawyer, and this is not legal advice, but this is about as close to that as I can get. The way I would be advising a client if they were asking, oh, okay, so we have these monies available through the state, we want to run that first before we go the paid sick leave route. I would advise against that, because if I'm eligible for the paid sick leave and you don't provide that to me, there's liability and compliance issues there, whether or not the state says there's other funds available. So I would, in sequence, apply the paid sick leave first, and then if you want, you can then apply this program through the state for those who you want to continue to pay for quarantine or isolation. Sorry, my phone just rang. Forgot to mute that. Okay, so the documentation that you need to justify in the application for the grant money, you need a copy of the positive test, and you include that with the grant application. For those who are in close contact with a COVID person, the contact tracers, those individuals who are making those, providing the analysis and tracing down those individuals, they can also provide a certificate. If we have a surge of cases, kind of like we're experiencing now, the contact tracer may provide the certificate to the employer, just notifying you that, hey, one of your employees has tested positive or they've been in close contact. And then you can submit that as part of your application also. For those who are in close contact but are not receiving these notices, there is an option to just email the state at contact.tracing@utah.gov, and apparently they will provide you with this positive notice that allows you to process the application. I haven't tested this to see if it works. I'm curious if someone actually has, but this is what the Labor Commission instructions have provided for us to do. All right, so that's a modification and an additional thing to consider as you navigate paid sick leave. Okay, moving to the emergency FMLA. As I mentioned, this is an intersection with the paid sick leave. We have one justification for an individual to take leave under the emergency FMLA, and that is, again, I, your employee, am caring for my son or daughter if the school or the place of care has been closed or the child care provider is unavailable because of COVID-related circumstances. As a reminder, this is only available to an eligible employee who must have worked and been on the payroll for at least 30 calendar days. It also takes into account this individual's prior use of traditional FMLA. So we only provide up to 12 work weeks of leave for this emergency FMLA between April 1st and December 31st. But in counting those available 12 work weeks, we do look to prior use of traditional FMLA. Now, for those of you very familiar and comfortable with the FMLA, your mind should be thinking about, well, what's our 12-month measurement period? Because that 12-month measurement period influences what happens for available FMLA leave. Well, you have to take that into account and then basically overlay it with the paid FMLA from April 1st to December 31st to make an accurate calculation of what leave is available of the total 12 for the FFCRA version of paid FMLA. Pretty complex. And if you need help with that, please get a professional, talk to an employment law attorney, make sure that you're tracking and allocating that leave appropriately. Okay, well, how much leave or how much money do we provide? Well, first, let's talk about how much leave is available. Again, the language of the paid FMLA provides that the first 2 weeks of paid FMLA are indeed unpaid. So this emergency FMLA grants 12 weeks total, the first 2 of which are unpaid. Now, in that first 2 weeks, if the employee chooses and they meet the requirements of the paid sick leave, they can use those 2 weeks as payment for the total, those first 2 of the paid FMLA. The remaining 10 weeks of FMLA are paid, but they are again at 2/3 of that weighted regular rate. And there, as a reminder, is the formula for you to consider. The payments are also capped at $200 a day for a maximum of $10,000 total over that 10-week period. All right. That's the overview of the paid sick and the paid FMLA. Let's move now to school. And this, frankly, for many of us, is a moving target. I'm in the Davis School District, and next week it changes again for my kids. I have 2 kids in secondary school and 2 kids in elementary school. And we've been on differing schedules, but next week it's going to align finally. So here's a couple scenarios that I want to go through. These come right out of the frequently asked questions, which is one of the links that I gave you on that first slide. And these examples address the various situations that could arise as parents manage their children's school schedules as schools open and close based on COVID changing circumstances. So here's situation number 1. My child, or your child, is operating, their school is operating on an alternate day or a hybrid attendance basis. So the school's open one day for some kids, but closed for other kids on that same day, and then it flips. So one day I'm at home, next day I'm at school. And these children are permitted to attend school only on their allotted in-person attendance days. Well, the question many of your employee parents are asking is, may I take paid sick or paid FMLA on these particular days? I'm going to give you a moment to ponder the answer to that question. And here's the answer. It does. So the FFCRA leave, again, reason number 5 under the paid sick leave or the paid FMLA would apply in this situation, and your employee may take paid leave on days when their child is not permitted to attend school in person and is learning remotely. Now, remember that the leave is available only if you actually need it to care for your child during that time, and if no other suitable person is available to do so, and work is available. Now, no other suitable person, this in a different presentation came up as a question, well, who does that include? So I'm the employee. From your perspective as my employer, who would you consider to be another suitable person? Well, it's my spouse or a guardian or another person who typically cares for or watches the child. So if that person is not available, then no other suitable person is available, and I would meet the eligibility requirements for this version of leave. All right, next. My child's school gives me a choice between attending in person or participating in a remote learning program? Well, I, the parent, chose to sign up for a remote learning alternative because I'm concerned about COVID and contact with my children with it at school, and I don't want them to bring it home. So I'm choosing to keep my child at home. May I take paid leave under the FFCRA in this situation? I'll let you simmer on that for a moment. In this instance, it does not apply. And the fundamental reason why is because the parent chose to keep the child home. In other words, the school is not closed to the child. It's open, but the parent chose to keep the child at home. So the FFCRA in that situation wouldn't apply. However, if because of COVID, your child circumstances change such that, for example, they fall under an order to quarantine or isolate, or they've been advised by a healthcare provider to quarantine or isolate, then the circumstances change and we look to other justifications for the paid sick leave, in which case your employee may be eligible for the leave at that point. All right. The third example from the regulations addresses this situation. So my child's school begins the school year under a remote learning program, so everyone's at home, but has announced that we're going to evaluate and that we're going to adjust depending on the circumstances. So right now, we are at home, but it may change in the future. Your employee asks, may I take paid leave under that circumstance? I'll let that ruminate in your minds for a moment. In this instance, they are eligible. And that again, fundamentally is because right now, at least, the school is closed to your child and they are exclusively forced to remote learn at home. Therefore, we meet the FFCRA definitions and the leave would be available for one of your employees. Now, in the Davis County situation, November 2nd, next Monday, the secondary schools will go to a 4-day live in-school study with Friday being closed and everyone at home. So for those of you whose employees may have been using paid sick leave or the paid FMLA for the alternating schedule, next week, that's going to change. And because the school is now open for everyone, then the FFCRA would drop off on those days that the school is open to everyone. Fridays would, of course, continue to be closed for the students, and the leave would then be available to eligible employees on that particular day. All right. I haven't seen any questions, so either I am really confusing or really clear, or the coffee hasn't kicked in. If it's any one of those, please remember you can put your questions up. Happy to address those. Oh, thank you, Brian. That's very kind. All right, so let's move into some common questions that I've experienced and a lot of employers have had, but also that the regulations go to great lengths to point out and make sure that we are clear on. And we'll wrap up with this section in these last few minutes that we have. Okay, so first, notice. I, as the employer, require typically or expect that my employees will give me notice of when they're not coming to work. That's just standard operating procedure. The FMLA allows for us to do that. Well, how does it work under the paid sick and the paid FMLA? Well, as I mentioned earlier, and I want to be clear on this, under the paid sick leave, notice is not required in advance. You cannot require that your employee tell you in advance that I'm not coming to work and I'm taking paid sick leave tomorrow. You can, however, require that after the first workday or a portion of that first workday that they do take the leave, that they then provide notice to you of what's happening and why they didn't show up for work. Emily just posted a question, are public employers eligible to get reimbursed for the paid sick or the paid FMLA? I'm I would assume so, because again, you're withholding money from your taxable withholdings, and that process, as I understand, is the same as it is for a private employer. I withhold taxable wages both as a private or a public entity, and then remit those to the IRS. So that taxable withholding, that bucket of money, is what you then use to pay out the paid leave, paid sick or paid FMLA, and then you apply for the tax credit through the IRS process and application. So yeah, I would say yes, it is the same. Going back to the notice, for the FMLA, it's a little different, and this aligns with the foreseeable and unforeseeable standards required in traditional FMLA analysis. In foreseeable leave, or when we have foreseeable leave, generally that means I know in advance that I'm going to not be able to come to work. Think traditional FMLA. I'm having surgery in 3 weeks. That's not a surprise. I know it. I scheduled it. And I'm now required to give notice to my employer that I'm going to be gone and FMLA may apply. Well, the same analysis applies in this situation. So think about that in the context of Davis County Schools, for example, next week. It may be foreseeable that leave is changing. And I know that because I've been notified by the school district that this is what's happening. So for the paid FMLA, it would be reasonable for the employer to require notice in advance of the employee's need for paid FMLA, only the FMLA. Now, if it's unforeseeable, meaning the school, we had a breakout and they closed the school today, everyone's sent home and I need to go home. Well, that's unforeseeable. I didn't plan for that and I didn't know it. So the requirement for your employee to give you notice is as soon as practicable. Notice it's not as soon as possible. The regulations do make a difference in that language. So it's as soon as practicable. All right, well, so I've received notice. What can I require that my employee provide to me to justify their leave? And for those of you who are thinking about the IRS process and how do I apply for and justify the tax credit, you're thinking, well, paper, I need something to justify that. Well, here's what you can ask for and require from your employees. Now, this is where there's an interesting overlap between the DOL regulations and the IRS regulations. Let me go through this and then I'll address your question, Connie, that you just posted. So the documentation, first and foremost, that we can ask, and this is for paid sick or paid FMLA. First is the employee's name, obviously. Second, the date or dates for which leave is requested. Third, the reason for leave. So if it's paid sick, reasons 1, 2, 3, 4, or 5. If it's paid FMLA, it's the only reason, but I would still have them declare that. And if it's for reason number 5 for paid sick or reason number 1 for paid FMLA, you can require that the employee give a statement that they are unable to work because of that qualified reason for leave. And if it's for reasons number 5 for the paid sick and reason number 1 for the paid FMLA, that no one is available to take care of the child. And I'll kind of bumble through that. I'll cover that a little more clearly on the next slide. Let me finish the documentation, this next one, Connie, and I'll come back to you. Okay, so I'm also allowed to ask for additional documentation when the paid sick leave reason is one of these. So reason number 1, remember, there's an order through a state or federal agency that says quarantine or isolate. Well, if my employee is taking leave with that reason or for that reason, I can also require that the employee provide me the name of the government entity issuing the order. Now, be reasonable with that. If you know that the state of Utah has issued this directive and it's in their business manual and it's on their COVID page, print the page. You don't need to require that the employee do that. You can grab that documentation. So just be reasonable. It's an encouragement, not a hammer that you want to beat the employee with. If it's reason number 2, which is the healthcare provider has advised me to self-quarantine or isolate, well, we can ask for the name of the healthcare provider who made that advisement. For number 3, remember, is I am symptomatic and seeking a medical opinion. Well, we don't have any guidance on that, so you can't ask for anything in that situation beyond what was listed on the previous slide. And if I am caring for someone who's subject to number 1 or number 2, then you can require of that employee that they provide, again, the name of the government entity that issued the quarantine or isolation order, or the name of the healthcare provider who's issued that advisement to quarantine or isolate. Okay, Connie, to your question. First, you have an employee who's tested positive, was out for 2 weeks, paid with FFCRA, and I'm going to assume that that means the paid sick leave. Employee comes back for 1 week of work. Now his family member is tested positive. He's already used the 80 hours of FFCRA, again, the paid sick. Is he eligible for more? No. That is an 80-hour cap. Under no circumstances can that employee exceed for paid sick leave more than 80 hours of wages, of that wage supplement. Now, you can, of course, pay more. You can do more than the 80, but the tax credit will not apply. Now, think about that state program, the grant money that is available, that would apply in this situation. So you could, if you paid for that individual to, again, be out of work because of a quarantine order, because of close contact in this instance, you could apply for those grant funds and have that reimbursement of the wages that you pay. Now, this comes out of your pocket, though, and is a reimbursement from the state with those grant monies. That would apply in that instance. Great question. Okay, going back to the documentation. When it's reason number 5 under the paid sick or the FMLA paid reason, remember, you can ask for this additional information from your employee. The name of the son or daughter whom the parent is caring for, the name of the school or place of care or the child care provider that is closed or unavailable, and a representation that no other suitable person will be caring for the son or daughter during leave. And again, reminder, no other suitable person. What that means is, well, at least what the regulations and the FAQs give as an example, is it's a spouse, a guardian, or someone who has typically and traditionally been caring for the child in previous instances. So if any one of those individuals or all of them are not available, then no other suitable person can care for the child, and they would qualify for the paid sick or paid FMLA. All right, next question, typical issue. Do we apply block leave or intermittent leave? Now, this looks and feels, and the logic behind this tracks very much behind to the traditional FMLA. For block leave, this is the default option. This is where we start. So for the paid sick leave, we're thinking initially it's block leave. You get up to the 80 hours of paid sick, and then it's exhausted. Well, you can, in some instances, allow for intermittent leave. Now, intermittent is anything less than a block leave. It's I'm here and then I'm not, and then I'm here and then I'm not, or I'm taking it and then I'm not. All right, now here's where you have to think about where work is being performed. If the employee can telework, then yes, intermittent leave is available, but only if you, the employer, agree and the employee is unable to work their normal schedule. So if you do agree and the employee is unable to work their normal work schedule because they can't, make widgets, for example, when they're working from home, and you agree to this, you can allow them to telework. So you can allow them to take the paid sick or the paid FMLA in any leave increment. If you do that, my advice and the regulations suggest that you have a written or clear mutual understanding. That could be an email, that could be on the form where they request leave. You could define what is that clear and mutual understanding, spell the terms out. And the DOL also throws in this last little plug. They encourage collaboration
and want you to achieve flexibility in applying these laws. Now, if work can only be performed at the work site, meaning my presence and the functions I perform can only happen if I show up at my work location. Intermittent leave is available in that instance, but only for the child care provisions of the paid sick or the paid FMLA. In other words, if I have to come to work to perform my job, but I have been exposed to someone through close contact, or I've been advised by my doctor to quarantine, or I'm under an order to quarantine or to isolate, or I'm caring for someone who's under any one of those, I don't want you at work. And the public policy is we don't want you at work either. So intermittent leave in that instance is not available. So once again, if the work can only be performed at the work site, intermittent leave is only available in the child care option under the paid sick and the paid FMLA. Hopefully that was clear. All right, well, leave is done. Now what happens? Well, we have, again, very similar to the FMLA, reinstatement rights, position restoration under the FFCRA. And this applies for both paid sick and paid FMLA. The restoration rights will look and feel, again, like traditional FMLA. It is be restored to the same or an equivalent position, which it refers to the FMLA regulations, and they are defined as being virtually identical in terms of pay, benefits, and working conditions. So let that be the guide and benchmark when you restore that employee to their job. You don't want measurable differences in what they did before leave with what they're doing after leave. Restore them to what they had. Now, this question came up quite frequently a few months ago. Well, we laid everyone off, or we closed all of our doors and no one's working right now. Do we have to restore that employee? No, you don't. If they went on leave, they're not entitled to any greater rights than they would have if they were continuously employed. So if I was continuously employed, I would have been furloughed too. So in terms of restoration, I don't have to bring the person back if everyone else is gone too. All right. There is an exception for this though. If you are an employer with less than 24 employees, you have an exception to position restoration, and it only applies for the school closure or the child care justification. So the employee took leave for the child care reason or the school closure. The position no longer exists due to economic conditions. You've made reasonable efforts to restore the employee to equivalent position. And when those reasonable efforts have failed, and this I think is really interesting, you have to make reasonable efforts up to a year after leave to restore to contact and try to restore that employee to the position if it becomes available. Only if you meet all four of those requirements can you exclude or not provide the position restoration for employers with less than 24 employees. Now, we are counting down 3 minutes, and I want to cover something, so I'm going to skip a few things that are in the slides. You'll have these definitions modified for healthcare providers and the definition for emergency responders. I want to cover this. This is another exception or an exemption from leave. So if you are a small employer, which in this instance is defined as less than 50, you can deny FFCRA leave for childcare or school closure if compliance with the FFCRA would jeopardize your business viability. And here's how they defined that. It's one of these three. How this will be defined, or analyzed and defended, we have no idea. But this is what the regulations say. So if you have less than 50 employees, you can deny paid leave to an employee for the paid sick or FMLA for child care options if you meet one of these requirements. Now, I'm not going to read them all. You'll have the slides to go through, but it's meet one. And then, of course, and this is the defense attorney in me speaking, document it and defend it, because you're going to have to justify why you denied leave. Because if I'm the employee and I disagree, I'm going straight to the DOL for an enforcement action because I should have my leave. And at that point, you're going to have to defend it and document it and justify it. So with that in mind, plan ahead. All right, the final thou shalt nots with the FFCRA. Under the paid sick, this is a wage and hour enforcement mechanism. So we track to the Fair Labor Standards Act for this. You cannot discharge, discipline, or discriminate against any employee who uses this time, or files a complaint or participates in a process to enforce the FFCRA. If it's the paid FMLA, it's unlawful for you to interfere with, restrain, or deny their rights, or to discharge, discipline, or discriminate them. And that follows the FMLA enforcement mechanism. Martha had a question which I will respond, and then I'm out of time. So if an employee's been quarantined due to exposure, and that employee goes and gets a test and comes back negative, can they come back to work at that time, or do they still need to quarantine for the 14 days? They need to quarantine for the 14-day period. Now that CDC and state of Utah guidance, there is an exception for essential workers. If they test negative and are asymptomatic and you fall within an industry that is defined as essential, then you can bring them back. But the CDC spells out very, very specific protocols to do that. And not everyone's going to fit within that exception. So generally speaking, if I had close contact and I am now quarantined, I am quarantined for that 14-day period. And you, the employer, you are well in your rights to enforce that 14-day quarantine period before you allow the employee to come back. All right, with that, Darren, I'll turn it back over to you because I'm done. And you're on mute too.
Yep. Hey, all right. Hey, thank you so much, Ryan. We really appreciated your presentation today. It was very informative. And again, for those that would like to reach out to Ryan, there is his contact information. Just for those that may have joined our seminar midway through, a couple of announcements. The Department of Workforce Services is sponsoring a virtual job fair tomorrow. If you would like to participate, my contact information is in the chat. Also, we have another one coming up on the 3rd of December and January 7th. And then as a reminder, the Chamber is sponsoring a consumer service or customer service perspectives in business to business and business to consumer environments. This is on November the 13th. It's part of the Northern Utah Business Symposium. These are excellent, and you want to make sure you attend these events. We have 4 individuals in our community speaking and addressing these subject matter. One is Jill Calton from UBM Fund Services, Matt Wardell from JD Machine, Tara Lindstrom from Jamba and Biology, and Justin Callis from Sam's Club. So make sure you attend that event. Lastly, with the SHRM credits, if you are seeking SHRM credits, you must have been on the line for at least 45 minutes for today's presentation in order to get credits. You will want to reach out to Lisa or myself for those credits, and we will make sure you get the access codes. I also want to recognize the Northern Utah Human Resource Association, a member or chapter of SHRM, for sponsoring this event as well and providing us with the credits. Again, I look forward to our next seminar in May of 2021. And as a reminder, we are meeting as a committee next month on November 18th. With that, have a wonderful day, and thank you so much for joining in.